Good morning, everybody. I'm Judge Michael Davis, and this is the first appearance court. I'm going to take just a brief minute to say happy to be back here in the court, and I'm happy to be back with my former staff. This is a live broadcast streamed online, and I want to thank everybody that has called my office and texted and written letters. There have been a lot, and I appreciate everybody. Some questions from people online were, where are you now, Judge? I had the opportunity to sit as a temporary circuit court judge and also a county court judge, so that's what I'm doing now in the domestic division. And but I'm happy to be here. I'll be here with you all week through Thursday, and then Judge Williams will be here on Friday. To those of you that are with us today in custody, this is the first appearance court. You'll likely just watched a video where I explained a little bit about what's going to happen today, but I'll just briefly explain again. You're here today because you've been arrested, and under the laws of the state of Florida, you have the right to see a neutral judge within 24 hours of your arrest. Now, today's hearing is not a trial. What we're going to do today is I'm going to determine whether or not there was probable legal cause to arrest you. And if there was probable cause, I'm going to set a reasonable bond or bail in your case if it's applicable under the law. Now, you have the right to remain silent. Anything that you say can and will be used against you in further proceedings. Everything that you're saying today is being recorded both audio and visually. So today is not the day to discuss your case. Anything that you have to say, you may want to say to your attorney. Now, talking about that, every one of you has the right to counsel, to be represented. Today, it would be completely free, actually, for today's hearing. The public defender's office is here in my courtroom. There's also a representative there in the main jail. And whether or not you're going to hire an attorney in the future, they are here to represent you. If you already have an attorney that you've hired, let me know. And if they're not here, I will try to contact them for you. You have the option to represent yourselves, but as I said, there are attorneys here available today for you to represent you. We're going to go down the list today. I pulled a few cases out of order because we have some municipal ordinance cases from the city of Fort Lauderdale, and we have their public defender here with us today. It's Mr. Odom. So I will call Michael Tapia.
North
first.
Broward.
All right, very good. And good morning, Hector. How are you, sir?
Good morning, Judge.
Good to see you. All right, let's go over to North Broward. All right, North Broward, do you have Michael Tapia? Hey, good morning, Deputy. How are you?
How you doing, Judge Davis?
Good. Great to see you. Michael Tapia, Michael Scott Tapia.
Tapia, come on.
Hey, good morning again, Judge. Always a pleasure to be in front of you.
Same to you, sir.
Standing in on behalf of Ms. McLawrence for the this case as well as the subsequent municipal ordinance cases that I'll be calling in your courtroom this morning. Page 3, Mr. Tapia. First, Mr. McLawrence is moving to be appointed on the case.
All right, so ordered. I'm going to appoint, sir, an attorney to represent you free of charge. That attorney's name is J.R. McLawrence. The gentleman that's here today is his associate, Mr. Odom. Thank you so much.
Judge, I've been advised that Mr. Tapia looks to resolve his municipal ordinance case. Count 2 is a standing in the road solicitation, but that's a traffic infraction. So, technically the court can handle that as well, but I'm only speaking on behalf of the municipal ordinance.
Got it.
If the court would be open and inclined to an adjudication time served on the municipal ordinance case.
Say again. I'm so sorry, George.
No worries, Judge.
Would the court be inclined to?
Adjudication time served on the solicitation municipal ordinance violation.
Yeah, we can do that, and I'll dismiss count 2, which is standing in the road soliciting business to traffic, a traffic infraction. So I'll dismiss that case. Count 2. So, sir, do you want to plead no contest to count 1? I'll find you guilty, and I'll sentence you to time served.
Yes, sir.
All right, you're also going to have to pay some court costs. You're going to have a year to pay those. Okay?
Okay.
All right.
Okay.
All right. Now, don't go back to that intersection, okay? Because the police officer says he warned you the day before, then you went back. So, if he sees... It's okay. I understand, and you're on hard times. I completely understand. Just not a good idea to go back to that intersection, okay?
Yes, sir.
All right, so go ahead and read. Sure.
Sir?
Yes, sir.
Do I get out today?
You're going to get out today. You're going to get out today. I'm going to take your plea. I'm going to take
Because my jaw's wired shut and I got an appointment Wednesday.
Okay. You're gonna,
So I just wanted to see if I was getting out.
yeah, you're gonna get out today. You're gonna get out today. How come? What happened to your jaw?
I got in a fight and it got broke on one side twice and once on the other side.
Okay. All right. But you have your appointment. You're gonna get some follow-up care for it.
It's Wednesday.
All right.
This
This
Wednesday.
this Wednesday. All right. All right.
Yes.
Good. All right. No, you're not gonna miss it. Don't worry. You're gonna get out today. You have a place to go for the night. You have a place to sleep.
I think so, but I'm in a place where I don't know how to get back to where I'm supposed to be.
How are they doing? Oh, you're at North. He's up in the North Broward. Deputy, they have any bus passes up there?
Most of the time they have bus passes and intake when they release them.
Okay. All right. All right.
If he asks for one, they'll give him one if they have it.
All right. Can you, whoever the discharge deputy is, maybe just phone down to them, see if you can get them a bus pass.
All right, as soon as I get done, I'll call down. I think you
All
have
right.
to do more for me, then I'll make that phone call.
All
see if they have
right.
it.
I appreciate it. We're gonna try to get you a bus pass, okay? So you can get where you need to be, okay?
Okay.
All right.
Thank you.
They're gonna discharge you today. It might be a few hours because you got to go through the process, okay? But you'll get out today. Just raise your right hand for me, okay? You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right. I'm just going to ask you a few questions. I'm not going to make you talk too much because your jaw, okay? But I just need to make sure that you want to plead a no contest to this charge today. You're doing it of your own free will. Is that right?
Correct. Yes.
All right. You understand, once you make the plea, the case is over. We can't take it back. We're not going to have a trial. Case is going to be all done. You're going to get out today. You'll have a year to pay some court costs, and I'm going to find you guilty of the offense, and I'll dismiss count 2. You understand all that?
Yes, sir.
All right, very good, sir. All right, good luck. They'll get you a bus pass. Deputy Nethery will take care of it. He'll radio down to them, and you make sure you make that appointment, okay? I don't want the jaw to get worse.
Oh, I will. I haven't eaten in over a month. I'll make sure. I got wires in here.
Do they tell you to take liquid nutrition to ensure or something like that?
Yeah,
All right, all
but
right.
that gets old.
I know, I know. All right, good luck to you, sir. Take care of yourself.
Thank you very much, Ronnie.
All right, Judge Davis, I already called. They have blood passes. They'll make sure they give them one.
Oh, thank you, Deputy. I really appreciate that. That's great.
Okay, so one.
How have they been? Should I hand you each? I'll just hand you each. All right, we'll play our game of frisbee. All right, Bradley Vaughn.
He's at Maine, Your Honor.
All righty.
Judge, again, George Jordan on behalf of Mr. McLawrence, moving to be appointed to his case.
All right, yes, very good. Sir, Mr. Vaughn, I'm going to appoint a lawyer to represent you free of charge. It's going to be the law firm of J.R. McLawrence, and the gentleman here is Mr. Odom. He's his associate. Okay, looks like you had a warrant for possession of controlled substance, and just something you want to resolve?
Yes, Judge, I would ask the court to consider with.
Hang
I
on.
had 54 days in on the charge, sir.
Okay, hang on one
If you
sec.
check,
I promise you that your lawyer is doing a really, really good job for you. Let me just chat with him for 1 minute. We're gonna be able to resolve this today, okay? But let me just talk to Mr. Odom. He's really good at this. Go ahead, Mr. Odom.
Judge, I would want to ask the court to consider withhold of adjudication and court costs with time to pay. My only other request is that I know Mr. Vaughn, or at least I believe Mr. Vaughn's original case is in Judge Lerner Wren's division.
Okay.
I would ask the court to he seems to be fine here. I just would ask the court to just inquire as to mental health as far as in making sure he understands the process so that there's no.
Is it in her regular division or is it in the?
I saw her name and I don't know if it's her regular or if it's her mental health docket.
Do you happen to know, Mr.
So I'm
If you look in the booking sheet, or if there's a KPS, does it say MI?
It's a regular division.
Okay, well then, Judge, I withdraw that. It's in her regular division. I just wanted to be safer than sorry.
Yes, no, I agree. All right, sir, if you want to plead no contest to this charge, I'll withhold adjudication, and you'll have a year to pay some court costs. You'll get out today, and the case will be over and done with. Want to do that?
time served,
Time? Well, it's not even time served because I'm not even going to find you guilty. Okay, I'm just withholding adjudication.
but I'll get out
You
today.
get out today.
All right, okay.
All right. So just go ahead and raise your right hand. You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, good luck to you, sir.
Yes, sir.
All right, go ahead and put your hand down. Tell me your full name.
Bradley Cole Vaughn.
All right, Mr. Vaughn, you've been charged with possession of a controlled substance. Do you want to plead no contest to that charge?
Yes, sir.
All right, do you understand by pleading no contest, you're giving up your right to have a trial?
Yes, sir.
The case is going to be all done today. There's no going back to it, and the
This is how she
the
lives.
sentence that I'm going to give you, I'm going to withhold adjudication, and you'll get out today. Okay?
Awesome.
You'll just have a year to pay some court costs. Okay, sir?
Awesome.
All right.
Thank you.
Good luck to you. You take care of yourself.
You too. God bless.
All right. God bless.
I'm not, you guys should be doing it. You should be running.
John Dice.
Yes, page 4, Your Honor, and this is actually, it's Broward Sheriff's Office, Deerfield Beach Division. Moving, Ms. McLawrence is moving to be appointed to his municipal ordinance, county ordinance case, which should be number 2 on, well, you don't
Yes.
have a docket, but it's the sleeping in open, it's the new arrest.
Right. There's a resisting, which is the state charge, and then there's that county ordinance. Okay, so sir, let me explain. You have 6 total charges today. One of them is resisting without violence. You have several misdemeanor warrants out for your arrest. Possession of open container, resisting, disorderly conduct, and trespassing. And then there's another charge, which is a county ordinance. This is where things get a little confusing. The public defender's office is going to represent you, at least today, on counts 1, 3, 4, 5, and 6. I'm going to appoint a lawyer for you on count 2. That's the county charge. His name is J.R. McLawrence, and his associate, George Odom, is here, or his partner or friend is here to represent you today. So you're going to have 2 lawyers. That's the bottom line. 2 lawyers for the price of 1. How do you like that? All right, so the thing is, you have got warrants from other judicial divisions, other judges.
Judge, if I may, the sleeping in open doesn't, it appears to be, I looked at the PC prior to court this morning, it appears to be separate and apart from all the other counts that he's in front of the court for today. I would be inclined to ask the court to resolve it. However, being that it appears to be no bond on it. I mean, as far as he doesn't need any monetary bond.
Right.
And he has all these other pending cases. Quite frankly, I'm not in a rush to resolve it.
Yeah.
And thus, I would just ask, since we've been appointed, I'll leave the rest of the counts to the appropriate Mr. Reedy and
Judge,
Mr.
my conversation with Mr. Deese this morning is he's hoping the court would potentially resolve all the matters before it at this time. In exchange for his plea of no contest, he'd be asking the court to consider time served. Just for clarification, I believe count 3 is a municipal ordinance case as well.
Oh, is that? Oh, you're right. Yeah, that is. That's count 3 is MO20A. So would that be Mr.
Not
Shade?
not that one, Your Honor.
That one would be Mr. Shade. Okay. Mr. Linder, do you have a history for Mr. Dice?
Yes, Your Honor. First off, this is his 4th arrest this year. Earlier this year, he pled out a resisting without violence and trespass. Last year, resisting without violence, disorderly intoxication, trespass. 2013, resisting without violence. 2006, battery. 2002, DUI. States offer to resolve, both, actually, all 3 cases that I can make an offer on would be adjudication, 5 days, county jail.
Judge, I'm sorry, just to clarify, correct the record. The 3rd count is the one that I've done a order for, so that is the one that we're seeking appointment on.
Oh.
Count 2, the sleeping in open public, which is the one I've been referring to, is the one that we are not seeking appointment
Okay,
on.
that's the county ordinance. That's Mr. Shade, I think, does those.
Well, Mr. I think they have, and I looked it up, they may have the same number. Mr. Reed, can you do me a strong favor?
Let me just ask, the gentleman and all, Mr. Romero, if that's something that Mr. Dees is interested in, then we can, and I'll resolve the municipals and the county, same 5 days and the court costs.
In speaking with Mr. Dice, he wishes to accept that offer, Your Honor. The
Okay.
5 days, he already has credit for one, so it'd be
Good.
4 more days.
Good. All right, so let's get everything resolved today then. All the charges, it'll be all six charges, sir. So, go ahead and raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead and put your hand down and just tell me your full name.
John Henry Dice.
All right, Mr. Dice, you've been charged with resisting an officer without violence, sleeping in the open, possession of an open container of alcohol, resisting without violence, disorderly conduct, and a trespass charge. Do you wish to plead no contest to those charges today?
Yes, sir.
Do you understand that by pleading no contest to all charges, you would be resolving the case today without a jury trial? You're waiving your right to have a jury trial, and the sentence today would be final.
Yes, sir.
All right. Are you under the influence of any drugs, alcohol, or prescription medications today?
No.
All right. You understand everything I'm saying?
Yes, sir.
All right. Well, I'm gonna sentence you to 5 days in the county jail, and I'll take credit for any time that you've already served. So, like Mr. Romero said, you already did a day. Okay, so you get credit for that. After you get out, you'll have a year to pay some court costs, and there's an awful lot of charges here. So what we're gonna do is we're gonna reduce it to a civil lien. So that means that if you can't pay the court costs, you'll just have a lien on you. If you go to get credit or something like that, it'll just show on your credit report. But you got an awful lot of charges here, and I don't think you'll be able to pay. I don't think I'd be able to pay all those court costs within a year, okay? So we'll do a civil lien for that. All right, good luck to you, Mr. Dyson. You're gonna get released today.
All right, thank you, sir.
Good luck, sir. Mr. Odom, I think we have one more. Is it
Ye-
Anthony?
Page 5, yes, Judge, Mr. Bellamy.
Anthony Bellamy.
North Broward, Your Honor.
All righty.
Go ahead, stand on the edge.
All
How
right.
you doing, Judge?
I'm doing well, Mr. Bellamy. How are you?
I'm okay, Judge.
Good. All right, we've got 3 charges for you today. They're all municipal ordinance violations. We've got trespassing after warning, resisting arrest without violence, and destruction of city property. I'm going to appoint an attorney to represent you. His name is Jaron McLawrence. Today we have Mr. George Odom today, who's going to be representing you.
Okay.
I'm going to find probable cause for the charges. And does he have any significant priors?
Just need his BCCN.
George, this is something you want to resolve today?
If Mr. Bellamy wants to resolve, then I will go with Mr. Bellamy's request. Mr. Bellamy, if I may, Judge.
Sure.
Mr. Bellamy, you know what the 3 charges that you're charged with today? My name is George Odom. I apologize.
Yes, sir.
Okay, it's 1 count of trespass, 1 count of resisting arrest without violence, and 1 count of destruction of city property. As to count 3, there may or may not be restitution involved, depending on if there is some property that was damaged in this city of Fort Lauderdale is seeking compensation for that. The court is inclined to resolve your case today. There may or may not be a withhold, may or may not be adjudication. I'd ask the court to consider withhold on all 3 counts. My question to you are these charges that you want to potentially resolve today, or would you prefer to speak further with myself or Mr. McLawrence concerning whether or not you committed the alleged offenses?
I like to resolve it today, even though I didn't commit it. I didn't do anything, but I would like to resolve them today.
So you're saying you would like to enter a plea of convenience, which would be a no contest plea today on all 3 counts?
Yes, sir.
Here's my only problem. My only problem is I can't in good conscience take a plea from Mr. Bellamy while he's saying I didn't, do anything. He's professing his innocence, which is absolutely his right. I just don't feel comfortable taking that plea.
No, I'm okay. I'll take the plea. It ain't no problem. I don't want to be sitting in jail.
Well, here's what I'd ask the court in light of the court's concern and hearing Mr. Bellamy myself. It appears he only has a bond on 2, which is a $100 bond. Mr. Bellamy, do you have any money in the bank currently?
No, sir. I'm homeless right now.
Okay, do you?
I know, they
Okay.
was gonna accept me today.
Do you
If I can get out, I probably can be in the hack probably tomorrow.
do you have anyone that can aid with the $100 bond on the count two resisting without violence? Cash
No,
one.
sir. I don't have nobody. I'm homeless.
Judge, being that he is look like he's trying to get some temporary stabilization, I would just ask the court to release him on his own reconnaissance on count two, allow him to seek the services of the hack, and then have him appear back in court at the appropriate time.
Okay, can you get him your phone number? Because here's the thing, sir, if I release you on your recognizance, you're homeless, they have nowhere to send you the court date. So if you don't show up for the court date, what's gonna happen is they're gonna put a warrant out for your arrest, so,
No, I'll just keep in touch with the court. So I'll call the 6565-831-6565.
All right.
And let you know your court date.
all right, you should call every day because I don't know when they're gonna set that. The other condition of your, release on recognizance would be that you cannot go back to Snappers on, Broward Boulevard,
Yes, sir.
okay? So no return to Snappers, I'll release you on your own recognizance. Keep in touch, keep calling that number, or you can keep in touch with Mr. Odom, who can give you a phone number, or Mr. McLawrence, that's gonna be your lawyer. They'll be representing you when you go to the division, okay?
Okay, so I mean on all three counts, I got ROR or what?
Yes, well, there's no monetary charge on counts 1 and 3. There's only a $100 bond on count 2, which I'll release you on your recognizance. And like I said, is the terms of the release are that you cannot return back to Snappers, and that you must return to court, otherwise a warrant will issue. Okay?
Okay, charges 1 and 3, I don't have them no more, right?
You have them. There's just no monetary bond on them. There was no bond on them, but they're still there. Okay?
So I'll be released today?
You will.
All right, thank you.
All right. Good luck.
And I'm gonna make sure we get him a card.
No, I left the NC. Hey, good morning, Sheila. How are you? Good. What are you doing here in the morning? Shocking. Ah, okay. Thank you. All right, now we're gonna go back to page 1. Okay. For Danielle Johnson.
I believe it's a medical loan, Judge.
Okay, mid reset.
I think I gave it to you, since it's just out of state.
Betty Celestin.
Your Honor, that's North Broward. She's a medical reset.
Okay.
She
Come on
probably
in, Ms.
bonded out,
Lewis,
she
you're
bonded out last time. She bonded out last time, she'll probably bond out this time.
How have the judges usually been doing it? Do they just sort of let the pile build up and then give it to you, or do they just give it to you one at a time? Okay.
Cause it's just bizarre behavior,
All right, Sierra Lewis.
Good morning.
like someone comes to your house and you just start screaming and swinging a.
North Broward, Judge.
All right, good morning, Miss Lewis. All right, ma'am, you've got a warrant for your arrest,
Referring to her by her birth.
driving with a suspended license.
Yes, sir.
Bond on that is gonna be $500, ma'am, that was set by the division judge. And they were gonna set up a court date for you, Division MQ, I think that's Judge Gottlieb,
Yes.
okay?
Would the court be inclined to address the issue of that capias, the monetary amount on it? Or possibly even resolve Ms. Lewis's case?
Yeah, I don't think Judge Gottlieb would be adverse to me addressing the bond number. He and I have spoken about that before. He's comfortable with me raising or lowering, not that I'm raising,
Okay, just so we're clear on that.
not that I'm raising. Is this something that she wants to resolve today? I mean, it's a suspended, she might be qualified.
I think she'd rather get out on bond and resolve it that way. She has lived here all of her life. She does have family here, including her 2 children who are 9 and 5 years old. They're currently with her aunt and uncle. She's worked at Checkers as a cashier for the last 3 years. She believes her brother will be able to bond her out, but she's not sure. She indicates to me that her prior contact with the criminal justice system was a trespass or a tampering with evidence that was dismissed in the past. She's been living in the same location now for over 8 months. She indicated to me she attempted to confirm her court date. There was some confusion as to when she was supposed to appear in court, and that's how the capias resulted in being issued.
Okay. You still live in that Hallandale address?
Yes, sir.
So, all right, that's where they're gonna send the notice of the court date, okay?
Okay.
All right, I'll release you on your own recognizance today. They're gonna set up a court date for you to see Judge Gottlieb. So just make sure that you, keep an eye on the mail. You can also keep checking, with the court. There's a number online. I'm sorry, yeah, online. You can get the phone number. Keep checking to see when your court date is, okay?
Thank you so much.
All right, you'll get out today. Good luck to you, ma'am.
Thank you.
All right, Taylor Devine.
I've been advised, Judge, that Mr. Devine, bonded.
Okay, I'll find probable cause for the offenses. How about Marquita Woodson?
And Ms. Woodson is approaching, she's here, come on up.
All right. All right, good morning, Ms. Woodson. I'm Judge Davis. You're here on a violation of your felony probation. I'm sorry. You're gonna be held no bond at this time by order of Judge Tobin Singer. You're gonna see her on the 27th at 8:30, and you can talk about the probation, okay? All right, good luck to you, ma'am. You take care of yourself. Yesenia Calderon?
Ms. Calderon is approaching, come on up, ma'am.
All righty. Good morning, Ms. Calderon. You're charged with a petty theft in the first degree, and you have 3 felony warrants. I'm going to find probable cause for the new offense. It's going to be a $100 bond, and you're going to see Judge Porth very soon. They'll set up a hearing for you, and what I'll do actually is I'll release you on your recognizance on count 1, and then we'll see, perhaps Judge Porth be willing to release you to a program. All right? So, good luck. Hope everything works out.
2-1.
Oh, she won't get credit? Oh, Hector, can you call her back?
Come on up.
Good
Ms.
point.
Calderon.
Thank you.
Good point. Thanks, Sheila.
good point.
Thank you, Sheila. All right. You know, I was reminded that if I release you on your recognizance on that charge, you won't get credit for any of the time that you're serving. So I'm going to put the $100 bond back on, and then Judge Porth can always release you on your recognizance on that charge when you see him, okay? You understand?
Thank you, Judge.
Do you understand what's going on? Is she okay? Okay. All right, good. All right, you take care of yourself. Good morning, Ileana. How are you?
Chalk it
Nice
to-
to see you.
I mean, either way, it's not good, but
All right. Robin Holder.
North Broward.
All right.
we're about to find out in a minute. She talks.
All right. Good morning, Ms. Holder. I'm Judge Davis. You're charged with aggravated battery of a pregnant victim, and you also have a warrant out for your address from for your arrest from Judge Zeller for possession of drug paraphernalia. Now, that's the drug court division, and Judge Zeller has been ordered that you be held no bond on that charge. You're going to see her on the 26th at 1:45 p.m., Judge Zeller, to talk about that charge. Now, there's a felony charge here too, aggravated battery of a pregnant victim. I'm going to find probable cause for that charge, and Mr. Linder, if I could hear any priors, I know that there's
Yes.
a possession charge.
2004, out of Clay County, 2014 theft. 2013 out of Clay County theft, a grand theft out of Palm Beach County in 2010. Failure to appear, she was picked up in Green Acres, 2008. Fleeing and eluding law enforcement at a high rate of speed, 2005 out of Palm Beach. Possession of cocaine, Palm Beach, 05. Another failure to appear pickup in Palm Beach in 05. Another arrest for failing to appear in 05 in Palm Beach. Based on her criminal history, prior and present failures to appear in court and the allegations, state would be requesting a $2,500 bond on count 1 in order of no victim contact.
Your Honor, Ms. Holder's never going to be able to post that kind of bond. And speaking with her, she's been living here all of her life. She is legally blind. The only person who could possibly bond her out is her boyfriend. He has no phone, so she has no way of getting a hold of him. But I'm thinking sooner or later, he's going to figure out where she is and make an effort to try and get her out. She indicated to me that he could possibly come up with maybe $200. So I'd ask the court to post a bond. It's somewhere in that area that she could make, maybe $1,000 bond that she could make. And she goes to court tomorrow on the misdemeanor, so she has an opportunity to resolve that no bond hold tomorrow, which would make her eligible to bond out on the felony.
All right, let's make it a $2,000 bond then. And, ma'am, you cannot have any contact with the alleged victim in this case. It's gonna be Miss McEnroe. You gotta stay 500 feet away from her at least. You can't call, text, write, email, or try to find her on social media. Do you understand all of that?
Absolutely, that's not a problem.
All right, good luck to you, ma'am, and you'll see Judge Zeller tomorrow. Take
All
care.
right, thank you.
All right, Calvin Lee.
Mr. Lee is here, present judge at Maine.
All righty.
He declined the services of public defender.
All right. Sir, do you have a private attorney?
Yeah, sure.
Okay. Have you retained that attorney for this case, the resisting without violence?
Yeah.
All right. What's your lawyer's name?
Michael Tinzer.
Michael
Michael Tinzer.
Tinzer. Michael Tinzer. Okay. You don't have his number, do you, Eric?
I think I'll be able to get it in just 1 second.
We're gonna try to get Mr.
I've got it right here.
Okay, great. We're gonna try to get Mr. Tinzer on the telephone. Okay.
And could you inquire, has he retained him? Because I'm showing that Mr. Tenzer was court appointed in his other case he's representing him on.
Okay. So he's a special SPD.
It appears so, yeah.
All right, So Mr. Tenzer was appointed by the judge to represent you.
Okay.
Yeah.
All right, I'm gonna call him, because you're on pretrial release for a carjacking. And that pretrial release may get revoked today, so I'm gonna call Mr. Tenzer, okay?
And the number, Your Honor, is 954 468 3060. Yeah, with the GPS.
That might have. No, it went to the, thank you. Can you give it to me one more time?
Sure.
954
468
468
3060.
30. See, it keeps trying to, that's so strange. It keeps going to an internal line.
Let me see if I can get it through another means.
I'm trying it with one now, 954.
I'm gonna check his notice of appearance.
Okay, thanks. It's not, I don't think it's the number, I think it's the phone is going to like an internal courthouse number.
The call cannot be completed.
It does, but that's the number.
Give it to me one more time.
954
Uh-huh.
468
468
3060.
3060. Wow. So annoying. I don't know why it's going.
I'm gonna try for my phone.
All right, thanks. The prosecutor is gonna try to get Mr. Tenzer on the
Hi,
phone, okay?
Is Mr. Tenzer?
All right.
Is this 468 3060? Oh, okay, thank you. Yeah, it's doing the same thing. When I dial the whole number, it goes through an extension 3060 in the building.
Yeah, in the building. I know, it's very strange. All right. Something going on with the phones. All right, Mr. Lee, here's what I think I'm gonna do. I'm gonna just reset your case to the afternoon docket. We'll see you after lunch, because I want Mr. Linder from the State Attorney's Office to call Mr. Tenzer and see if he can be here this afternoon, or maybe be here by phone, okay? All right, so I'll see you.
Your Honor, the only thing I would ask is if the court could, and obviously it would be without prejudice, but if the court could make a determination as the PC, and only because I don't know that it would be just also that if Mr. Lee post bond and release, and then avoid having review of the violation of pretrial issue
Right.
prior to the afternoon hearing.
Right, I'm gonna order that the jail not accept any bond for Mr. Lee at this time until we have the hearing set for 1:30, okay?
So maybe darling, I'll call it.
I just wanted to make sure the deputy got that. Deputy, you there?
think Sheila, will you make a?
Sheila, you make the call? All right, thank you very much. All right. Deputy, we're not gonna accept any bond yet from the gentleman. We're resetting him to 1:30, okay?
Okay.
All right, thank you so much. So this will be a 1:30 reset. Thank you. And if you could try Mr. Taylor.
Yeah, absolutely.
All right, I appreciate that. All right, Walter Williams?
Walter Williams, he's
Yeah.
Absolutely.
Thank you.
Judge, could it be on recall?
Sure.
Thank you.
Sheikh Akhtar?
I've been advised she bonded, Judge.
Oh, okay. And Kamran Chowdhury?
I've been advised he bonded.
Bonded, okay.
In-laws beating up each other. Two in-laws beating up each other.
Uh-oh.
We have a silver
Charlatan Searcy?
leaf. Fight they had 6 months.
I've been advised, it's a medical loan, Judge.
Med Research,
Him,
okay.
him,
Cornelius
him.
Harris?
Mr. Harris is here present, Judge. He declined the service of public defender. He is approaching.
Okay.
you doing?
I'm-
morning.
I'm doing well. Good morning, Mr. Harris.
right.
You're charged with a burglary of an unoccupied structure and grand theft. I'm gonna find probable cause for those offenses. Did you hire a private lawyer?
No, I'm gonna have to when I get out.
You're gonna have to.
If you allow me to post bond.
Okay. All right. Let me hear from the state about it priors.
Yes, Your Honor. Mr. Harris's priors include. One moment, Your Honor. Now I know what he was referring to. Your Honor, Mr. Harris is currently out on bond for shooting at, throwing a deadly missile, possession of firearm by convicted felon, and aggravated assault with a firearm. 2011, could you check to see if he's registered? Introduction to contraband into a detention facility. 2009, 2 counts of lewd and lascivious battery on a victim under the age of 16. Resisting with violence, 08. I mean, it goes on from there, but those are the most recent and significant.
Yeah, I understand. All right. Mr. Harris, I'm gonna let you post bond today, okay? I'm not gonna revoke on your other case.
Yes, sir.
I'm reading the facts of this case. If you did any of these things, I see what you were trying to do. And, they're pretty different than the other case that you're out on right now, so I'm not gonna revoke that. What I'll do, sir, is I'll set a $5,000 bond on the burglary charge. It'll be a $1,000 bond on the grand theft charge. You cannot go back to Westway Towing Yard, unless it's to get your vehicle. Otherwise, if you have no business there, don't go back there, okay?
I try to get out of there.
Don't say anything about the facts of
Yeah,
the
don't
case,
talk
sir.
about the facts of the case. I'm just telling you, don't go back to the towing yard, unless it's to get your vehicle, okay?
All right, sir, can I say something?
Yes,
Any
but
possible way can you lower the 5,000 bond? Any
No, I'm-
possible way
He could have held you no.
I'm gonna keep the 5,000 in place and the 1,000, and good luck to you, sir. I hope everything works out.
You're not.
Thank
All
you.
right.
Yes.
The door, it locked again. Could
Oh.
you unlock it?
How
It
did
does
it-
it by itself.
It does it by itself. That's weird. All right, thanks. Keep me posted if it does it again. Thank you.
I've been doing it all day.
That's weird. DeAndre Bellum.
Mr. Bellum is here at Maine. He is approaching, Judge.
Okay.
And when you're ready, also, they brought back Mr. Walter Williams.
Oh, sure. We'll handle him next. All right, Mr. Bellum, you're charged with burglary of an unoccupied dwelling and a grand theft. I'll find probable cause. Mr. Linder, does he have any priors?
Yes, Judge. Could you see if he's anything outside of Broward Bellum? What's his last name? If he's not there, he's not there. In August of this year, he pled out a battery on a law enforcement officer. He was sentenced to 270 days. He was released September 13th. He also, on 2016, grand theft, He pled out the same 270 days concurrently in August of this year.
All right, Mr. Romero?
Judge, this being Mr. Bellin, he's been residing in South Florida his whole life. He's 23 years old. He's currently working at a car wash. He gets approximately $10 an hour. He's been working at the same car wash for approximately 8 years. He lives in Sunrise. He lives with his grandmother, his mother, his wife, and his 4 kids. He's a graduate of Dillard High School, class of 2010. His wife works at Ross. That's who's going to be contacting help post his bond. I'd be asking her what he can afford, Judge. We'd be asking for $1,000 on count 1. $1,000 count 2 would be a total of $2,000 bond.
Oh, sorry.
All right, here's what I'll do. I'll do a $3,500 bond on count 1 and $1,000 on count 2, sir. Good luck to you.
Thank you, Judge.
All right. Jarvis Butler?
Mr. Butler is approaching. He's here at Maine. He declined the services of public defender.
Okay. All right, good morning, Mr. Butler.
Do you have any criminal
You're charged with carrying a concealed firearm, threatening a public servant, resisting an officer without violence, failure to register a motor vehicle, driving with a suspended license is a second offense, and an expired temporary tag. I'm going to find probable cause for those offenses. Mr. Linder, does he have any priors?
No, Judge.
No priors?
No criminal history.
All right. Mr. Butler, what do you do for a living, sir? Do you have a job?
Yeah, I work at a warehouse.
Okay, how much money do you make an hour?
11.
$11 an hour, and do you work 40 hours a week?
Yes, sir.
Do you own any property, like a home or a car?
Case right before.
Yeah, a car and
yeah,
just a car.
He's got a pending case on.
Just a car? Okay, what kind of car?
A Galant.
Okay. All right, sir. I'm going to set a $1,000 bond on count 1. I'm going to set a $2,000 bond on count 2. It'll be a $100 bond count 3, $25 bond count 4, $100 bond count 5. There's no monetary charge on count 6, and you are not to possess any firearms, weapons, or ammunition. Do you understand, sir?
Firearms on one of our-
Thank you so much. Good luck to you.
It's fine. Or ammo, whatever.
Thank you, Keith. Will you do me another favor? Do you mind checking to see if the door is open now? Because I just got a text from Mr. Shate saying that,
Throw bullets at people.
yeah, he just said, I think Rick Patrick's trying to get in. All right, Michael Vouse. Oh, I'm sorry. No, never mind. I mean Walter Williams.
Mr. Williams is here, present judge at Maine.
All right. Good morning, Mr. Williams. You're charged with disorderly conduct and resisting an officer without violence. I'm going to find probable cause for the offenses. Does he have any priors?
Looks like his bond was posted, Your Honor.
His bond was posted? All right, so you're going to get out today,
Williams?
sir. It's a $100
Walter?
bond.
Thank you, Judge.
Wait. We're just confirming. It wasn't posted? His
Walter
name
Williams.
is Walter Williams.
You tell me.
Page 4? It was not, it was posted? No. It was not, okay, sorry about that. Your bond was not posted.
He's being supervised by pretrial release on 2 separate cases.
Is he?
All right, so you're being supervised already by pretrial for resisting without violence, trespassing, and a municipal ordinance lodging on a public park. All right. All right, sir. I'm going to revoke the
Just
pretrial.
got put on pretrial. He got put on pretrial over the weekend. So he didn't even report.
All right, here's what we're going to do. On 17-8495, MM10A, that's resisting an officer without violence and trespassing. Count 1 is resisting. I'll set a $100 bond. Count 2 $25 bond. Case 178496MO10A, lodging on a public park. I'll release you on your recognizance on that charge. I'll revoke, the pretrial release is revoked on both of those. I've signed that order. And I'll set a $100 bond on count 2 of this charge. There's no monetary bond on the disorderly conduct. All right. Good luck to you, Mr. Williams. You take care of yourself.
Thank you, Judge.
All right, sir. Michael Vouse.
Mr. Voss is approaching, Judge.
All righty. Good morning, Mr. Vouse. You're charged with a petty theft in the 2nd degree. This is a 3rd subsequent offense, so it makes it a felony charge, sir. I'm going to find probable cause for the offenses, and the bond will be $750. Good luck to you. Antrell Brown.
Mr. Brown is here present, Judge. May.
All right. Good morning, Mr. Brown. You're charged with possession of cocaine, trespassing, and you have 2 felony warrants out for your arrest from Judge Lynch. That is a grand theft auto and driving with a suspended license. I'm going to find probable cause. Bond on count 1 will be $1,000. There's no monetary charge on count 2. You're going to be held no bond on the felony warrants, and you will see Judge Lynch shortly. In a few days, they'll set up a court date for you, and he'll address all the cases, okay? All right, good luck to you. Good luck to you, sir. Eric Manning.
Mr. Manning's here present, Judge. He advised me that his friend will be posting his bond.
All right, very good, sir. You're charged with possession of cocaine and possession of drug paraphernalia. I'll find probable cause. Bond will be $1,000, and your friend will post it for you. You sure?
Yes, Your Honor.
All right, good luck to you, sir. You take care.
Thank you.
All right. Christian Sierra.
Mr. Sierra is here present, Judge. He declined the service of public defender.
All right. This probably should have gone to the domestic division, but,
Yeah.
sir, you're charged with an aggravated battery of a pregnant victim, and I'm going to find probable cause for that offense. Are you okay? Do you have any problems seeing me? I see you're squinting a little bit.
No, sir.
You're okay? All right, good. Mr. Linder, any priors?
Your Honor, I know. Let's see. Trespass in 2012, grand theft 2012, possession of marijuana 2009, and an arrest for failure to appear in 07. End of record.
All right, sir, I'm going to set a $2,500 bond on this charge, and you're to have no contact with the alleged victim. That's Miss Kajelgard, Joan Kajelgard. So stay 500 feet away from her and her property. Don't call, text, write, email, or try to find her in any way on social media. Do you understand that?
Yes, sir.
All right. Good luck to you, sir. You take care.
Thanks.
Stephen Toller.
Mr. Toller is here present, Judge.
All right. Good morning, sir. You're charged with burglary of an unoccupied conveyance and a grand theft. I'm going to find probable cause for the charges. Does he have any priors, Mr. Linder?
Yes, Your Honor. Let's see, it's most recent. 2004, trafficking in hydrocodone, DUI, 47 and a half months, Florida State Prison. 95, possession of battery. 1986, burglary of a structure with assault, possession of burglary tools, criminal mischief, and battery. Violated probation, sentenced to 5.5 years, Florida State Prison.
Okay. All right. Mr. Romero?
Judge, in speaking to Mr. Toller, he's been residing in South Florida for about 58 years. He's 60 years old. He is working. He works for a company called Complete Structure Painting. He just started. He just got that job, and it's paying him about $16 an hour. He lives in Hollywood. He lives in a trailer. He's been living in the same trailer for about 2 years. His monthly rent on the trailer is about $600 per month. Judge, he's an Army veteran. He has served from 1972 to 1975. I understand he has priors. He's gone to prison, but he said financially he can't afford to post any sort of bond. He's asking, Your Honor, if pretrial can verify, he's asking if you would consider pretrial release.
And Your Honor, state would object to pretrial while it's dated. He also has been sentenced to prison for escape.
I believe the escape was, about 20 years ago there, Judge.
That's why I said it was dated.
So you're living in a trailer. You got a good address.
Yes, sir.
All right. Here's what I'll do. I'll set a $2,500 bond on one and $1,000 on two. We'll make it pending verification. And I understand the state's objection.
May I also say something else, sir?
Not about the facts, though. Not
No.
about the facts.
No, it's not. When I was sentenced 10 years ago for possession and trafficking of hydrocodone, I was found guilty in October, and the judge allowed me to stay out and turn myself in January to do the time, and I did. I didn't run. I didn't do nothing like this. I'm not going to go nowhere. I mean, I'm 60 years old. I don't want to run.
Yeah.
But I just can't afford the bond.
No, I hear you. I hear that. That's why I'm going to let pretrial talk to you, and they'll get you on pretrial release. So you're going to have to check in with them. They'll set the conditions. You probably once a week. You'll have to check in, let them know where you are, and that way they'll ensure that. I don't think you're going to run either. To be honest with you, I think you're a really good candidate for pretrial. I understand your history, but. I don't think you're going anywhere either. So let's get you on pretrial. They're gonna re-interview you if they haven't already. They'll get your address verified. You live alone, or you live with somebody else?
I live alone. My wife died in April of this year.
I'm sorry to hear that. I'm very sorry to hear that. All right, I'm gonna go out on a limb. I'm just gonna release in the pretrial. All right, don't prove me wrong, okay? I'm just gonna release you to pretrial, and you got to check in. There's no clock in here?
No.
Two times. All right, 2 times a week, but I wanted to register with you by tomorrow morning. Can you make it over there tomorrow morning? Or if I don't know what time they're going to release you. If they release you this afternoon and the office is still open, it's right across the street from the main jail, you just go over there and register, okay?
Yes, sir. I'll do whatever you need me to do, sir.
All right, that sounds good. I'm just going to release you to pretrial release, okay?
Your Honor, we just asked for no victim contact.
Oh, yeah, so no contact with the alleged victim in the case. That's,
He's in Illinois. I'm sorry.
yeah, CWSI fiber optic, okay?
Thank you, sir.
All right, good luck to you, sir.
As soon as you're released, go across the street. That's the map to where you have to go to, okay? Good luck, sir, all right?
Thank you, sir.
All right. William Navard.
Mr. Navarro, is your present charge of me?
All right, good morning, sir. You're charged with a burglary of a dwelling or structure causing damage over $1,000, possession of burglary tools, and grand theft. I'm gonna find probable cause for the offenses. Stater, are you seeking?
No, Your Honor, I am going to be requesting on count one, I'm going to be requesting a $20,000 bond, and should Mr. Navarro post his bond pretrial release with a GPS monitor. This is based on, one, the allegations in the case, the amount of damage he allegedly caused to the church, also the strength of the evidence against Mr. Navarro, including but not limited to the surveillance video capturing the offenses and his confession. Also, Mr. Navarro is currently out on ROR on 2 separate drug offenses. One arrest was August of this year, the other 07. Neither's final decision has not been made on either offense. Additionally, out of the state of New York, 2012, he was convicted of, 2006, grand larceny of a motor vehicle. Out of the state of New Jersey, 2012, theft by unlawful taking. He was sentenced to state prison. Sorry, one moment, Your Honor, I just want to see the year. 2011, on a probation revocation for unlawful taking means of conveyance. Out of the state of Pennsylvania, actually, he was arrested in March on a drug offense. I'm not showing any disposition. That charge could still be pending. Your Honor,
That was this past March?
yes, this past March. Your Honor, I just believe the previous aggravating factors I've mentioned and the danger he poses to the community and property of the community heavily outweighs any any ties to the community he may or may have, and even if he has a lack of financial resources, I believe those aggravating factors heavily outweigh those factors.
All right. Mr. Romero?
Judge, Mr. Navarre, he's been residing in South Florida for approximately 4 months now. He did relocate from up north to here, South Florida, from New Jersey. He's currently employed. He did find work. He works at LA Fitness. He gets paid bi-weekly. He gets paid approximately $600 per week. Unfortunately, at this time, what he's doing is saving up in order to find a place to stay. Unfortunately, he's homeless. He has no money in the bank, no sort of assets, no sort of property. At this time, he is financially indigent, Judge. We'd be asking you to take that into account and determine a reasonable bond for Mr. Navarre's behalf.
Do you know whose division he's in on these two cases, 17-8183 CF10A and 9742?
Judge Colroy.
All right, that's good. Sir, I'm going to revoke your bonds on the open felony cases, 17-8183 CF10A and 17-9742 CF10A. And they're going to set up a date and time for you to go see Judge Colra. I want you to have a conversation with him. And if you were in my division, my sense is I would probably try to find you a program. You might even want to think about entry into the drug court if it's something that you might want to think about.
Judge, on that specific issue, would you sign an order allowing him to enroll in the SAP program? Since
Yes.
He's going to be in custody at the time?
We're going to do a SAP
Any
order.
on you? Any.
I'll do a $10,000 bond on count 1 and a $1,000 on counts 2 and 3. I just want to say something to you, and I want you to remember all of these are allegations. I really don't know if you committed any of these acts or not, but I just want to say something to you. I think it allegedly, if you did break into a church, I think it says something to me, which is that you probably were seeking a safe place for help, and you don't need a bolt cutter ever to get into a church. I don't think that the doors of a church would ever be closed to you, and when you do get out, I think that you could probably knock on the door of any church and or synagogue or mosque, and a person of faith would try to give you help. I know that might seem silly, and you may just walk away and say, screw you, Judge, but think about it, okay? For now, I'm gonna order that you not return to the First Methodist Church. All right, you'll see Judge Colera soon. Good luck to you, sir. Robert Telos. All right, good morning, sir. You're charged with violating your felony probation. The bond has been set in your case at $1,200, and you have a hearing set, I believe it's with Judge Fine, on September 27th at 8:45 a.m. So that's, what's today, Monday? So that's Wednesday. So if you bond out between now and then, just make sure you don't miss that hearing, okay?
September 27th, okay?
$1,200 bond?
Yeah, $1,200 bond. Good luck to you. Juan Aguilar.
Mr. Aguilar is here present, Judge, at Maine. He declined the services of public defender.
All right, good morning to you, sir.
Your Honor.
Yes.
I have,
Oh, good. I was going to ask about that. Sir, I've just been provided with some new documents in your case. Just give me one moment to take a look at them. Sir, do you need a Spanish interpreter? Do you want us to get an interpreter for you? Habla inglés?
I need somebody to speak Spanish.
Okay, all right. Can we order, please, a Spanish interpreter? Thank you. Sir, I'm going to call your case again. Hector, if you could just let him know, I'm going to recall his case.
Yes, Judge.
Thank you. Okay. Let me put this to the side. Daryl
No,
Hicks.
I don't think so.
Mr.
Two
Hicks,
cases. On two
All right.
cases.
Good morning, Mr. Hicks. You're charged, sir, with 2 counts of violating your felony probation. You're going to be held without bond at this time. Who took over for Judge Hames's division? Anybody know? Judge Bailey. Oh, you're right. You're going to see Judge Tim Bailey on Wednesday, 9 a.m., and he'll address those charges for you,
Maybe I'm
okay?
wrong.
Good luck to you.
Good luck, sir.
Johnny
No,
Soto?
you're right. It's Dennis Bailey.
Mr. Soto is approaching. He's here at Main Court.
Dennis Bailey.
All right, good morning, Mr. Soto. You're charged with resisting an officer without violence and unlawful possession of a personal ID or information of another, 5 or more. I'm going to find probable cause for the offenses. Mr. Linder, any priors?
One moment, Your Honor.
Thank you.
Your Honor, Mr. Soto is currently out on bond for 2 counts of sale or delivery of cocaine at a near park. 2015, resisting without violence and unlawful use of false name ID.
All right, what are the case numbers on those?
The case number is 174903 CF10A.
All right. Sir, I'm going to revoke your bond in case 174903 CF10A. You're going to have to go and see the division judge about that. There's no monetary charge for count 1. It'll be a $1,000 bond for the unlawful possession of the ID. Good luck to you, sir. They
just
will
wanted
set
the
a date
first
for you
page.
with your division judge soon.
Do
Benjamin Lewis.
Any priors on this guy,
I've
Lewis?
been advised Mr. Lewis bonded, Judge.
All right, I will find probable cause. Tuwan West.
North Broward, Your Honor.
North Broward, Judge.
All right. All right, good morning, sir. You're charged with grand theft auto, giving false identification to law enforcement, and you're also being held on a traffic warrant, driving with a suspended license, a second offense. I'm going to find probable cause for these offenses. Anything you wanted to tell me, Mr. Reedy, before?
Yes, Judge. Mr. West has been living here all of his life. He has 2 daughters, aged 8 and 4. He has extensive family here. He's held the same job for the last 10 years, working as a landscaper. He's been living in the same location for the past year with his wife and children. He is a registered voter. He has been doing charity work for FEMA, volunteering his time to help clean up some of the mess left by the hurricane. I'd ask the court, he can make the $500, I believe, on the capias, Judge. I'd ask the court to consider possibly releasing him on his own recognizance on the grand theft.
Any priors, Mr. Linder?
Yes, Judge. His criminal history includes 2015, he pled a felony out to a battery, resisting without violence, disorderly conduct, 2015. Failure to return hired or leased vehicle with a violation of probation, 2014. 2012, possession of cocaine with a VOP. 2010, attempted burglary of a dwelling with a VOP. He also has a $2,000 warrant out of Dade County for failing to appear in court.
Oh, it's an active warrant?
Yes.
All right, I'm gonna keep the bond, sir. $1,000 on count 1 and $500 on count 3. No charge for count 2. Good luck
All right,
to you.
I'll call your wife for you, Tuan.
Okay, thank you.
Brian.
North Broward's completed, Your Honor.
Okay, thank you, Deputy. I really appreciate it. All right. Brian Langston.
He's here at Main, Judge.
All right. Good morning, sir. You're charged with burglary of an occupied conveyance, resisting an officer without violence, driving with a suspended license as an habitual offender, fleeing or eluding law enforcement, failing
Yeah,
to stop or remain in an
3307.
accident
Don't write it
scene
yet.
involving non-serious injury,
07.
leaving the scene of a crash involving damage to property, and a learner's permit driver's license violation. I'm going to find probable cause for the offenses.
Yeah.
Does he have any priors, Mr. Linder?
Yes, Your Honor. No. Where's the other one? 818?
One from 831st and one 821. You have it?
Yeah. One moment, Your Honor.
Sure.
What is that?
Do you see it?
I'm trying to find that Grand Theft Auto. It says August?
818, one from 821, and then there's one from
Oh
831st.
my God, yeah. Your Honor, it appears that Mr. Langston is currently out on 3 separate felony matters.
Okay.
With all 3 arrests in in the month of August. The first being, he's out on bond for a Grand Theft Auto that he was arrested, August 18th. Out on bond for possession of PVP and false ID to law enforcement and operating without a valid license. He's out on possessing a forged driver's license, resisting an officer without violence. That's the 3rd case. Then you have this case. And additionally, his priors include 2017 trespass, 2015 unlawful use of false name ID, 2015 possession of PVP, he violated probation, was sentenced to prison. 2015 Grand Theft Auto, violated probation, sentenced to prison. 2011 burglary of a conveyance, just under 42 months state prison. 09 burglary of a dwelling with a VOP, he received the same prison sentence. Possession of cocaine, 2010 with a violation of probation, he received the same prison sentence.
Was released on June last year.
Can I please have the case numbers, the 3 felony cases?
Yes, just run down while I give them, please. The Grand Theft Auto is 179748 CF10A. The PVP is 179851 CF10A. And the possession of a forged driver's license is 1710196 CF10A.
All right, sir, I'm afraid I'm going to have to revoke your current bonds on those cases. They all in front of one division? All in one
Yes,
division?
they're all assigned to Judge Tim Bailey.
Judge Bailey, okay, all right, good. So, sir, I'm revoking bond in those 3 cases, and you will see Judge Bailey. This current case will likely also be assigned to Judge Bailey, so you'll
It
have an
is.
opportunity. It is
Yes.
assigned to, it's already assigned to Judge Bailey, so they will set a date for you to see him. On the burglary charge, sir, I'm going to set a $10,000 bond on that count. $100 count 2, $750 count 3, $2,500 count 4. I'll set a $3,500 bond on count 5, $100 bond count 6, and there's no monetary charge on count 7. And as I said, sir, you're going to have an opportunity soon to see Judge Bailey. I'm also going to order that as to the burglary charge, there be no victim contact,
Could you just write
so
no
stay
victim
away from the
contact
victim in
on
that
this,
case.
please?
Good luck to you, sir. You take care of yourself. Darrell Hamp.
Mr. Hamp? Darrell Hamp? He's approaching, Judge.
All righty. All right, good morning, Mr. Hamp. You're charged with violating your felony probation. Judge Rothschild has set your bond at $5,000, sir. You have a hearing with Judge Rothschild this Wednesday, the 27th, at 8:30 a.m. So if you do make that bond, make sure that you don't miss the hearing, okay?
No problem.
All right, good luck to you, sir.
Good luck.
Lawan Funches.
Mr. Funches?
All right, good morning, sir. You're charged with giving false identification to law enforcement, driving with a suspended license as an habitual offender, operating without a seatbelt, and a probation or community control violation. I'm going to find probable cause. There's no monetary charge on counts 1 and 3, $750 bond on count 2, and there's no bond for the probation violation. You're going to see your division judge on Wednesday at 9 a.m. to address that case, and he or she will likely be assigned the habitual case as well. Okay. All right. Good luck to you, sir. You take care. Clinton Flannery.
Mr. Flannery is here present, Judge?
All right. Good morning, sir. You're charged with possession of cocaine. I'm going to find probable cause for that offense. Any priors, Mr. Linder?
I believe so. I got it. Criminal history includes 2011 trafficking in oxycodone over 28 grams, delivery of cocaine, possession of firearm by convicted felon, possession of alprazolam with intent to sell or distribute, possession of cocaine and cannabis, 7 years Florida State Prison. Possessions of three possessions of cannabis between 07 and 08, and a possession of cocaine in 06 where he violated probation.
Mr. Romero?
Judge, in speaking to Mr. Florida, he's been residing in South Florida his whole life. He's currently working. He works in asphalt, laying down asphalt. He's been doing that for about 2 years, making about $10 an hour. He lives with his brother in Pompano. That's who he's going to be contacting to post his bond, his brother. He did tell me that he's had death in the family, so that's why financial resources are quite limited at this time. He's asking, Your Honor, if you would consider reducing the bond of $1,000 to $500. He's hoping his brother can afford that.
Your Honor, he was just released from state prison August of this year.
All right. I'll go for the 500, sir. We'll make it a $500 bond. Good luck to you. All right. Jerron Brown.
Mr. Brown? Good morning.
All right. Good morning, sir. Sir, you're charged with attempted premeditated murder. Well, it's the charge is premeditated murder, but I'm assuming it's attempt.
Well, that's why on the comment section of the booking, they write attempted, and that's what's on the warrant.
Right. That's what I'm going to find probable cause for. And are you seeking to have Mr. Brown remanded?
Yes, Your Honor.
All right. Mr. Reedy, did you have an opportunity to review the warrant?
Yes, I have, Your Honor.
Okay, good. All right. Any legal argument as to the remand?
Does he have anything else pending?
He has other charges stemming from this incident, but this wouldn't violate his release conditions.
Okay. Yes, Judge. If the state is asking for the court to find Mr. Brown, to hold Mr. Brown no bond on this charge, the court would have to make a finding that the proof is evident, the presumption is great. The court has been provided with a warrant to arrest. It has not been provided with any testimony. It has been not provided with any ballistic reports, which seems to be the main evidence against Mr. Brown in this case. The state has introduced no physical evidence, called no witnesses. Proof beyond a reasonable doubt is the highest presumption, is the highest standard that we have for detaining someone pretrial, higher even than proof beyond and to the exclusion of every reasonable doubt. Having reviewed this warrant that has been submitted to the court, it would be the defense's contention that this affidavit does not arise to that very high standard, and we would ask the court to set bond for Mr. Brown in this case.
Your Honor, relying upon Esau's v. State affidavit is all that the state is the state is able to satisfy proof evident or presumption great with an affidavit. What matters is what the alleged evidence contained therein. In this matter, Your Honor, the state believes for first appearance purposes that the proof is evident or presumption great that Mr. Brown, Jerron Brown, committed in a principal theory attempted first-degree murder. Evidence shows he was driving the vehicle where the shooting took place from, Your Honor. He was seen at the scene within the same time period as the incident, followed by law enforcement, apprehended by law enforcement, still in the driver's seat of the vehicle, Your Honor. He admitted to driving the vehicle. The vehicle's registered to his father. Casings were found from the shooting. And a gun was located as being discarded by one of the occupants of the vehicle that fled from law enforcement. Your Honor, the casings that were found matched, initially were the same type of bullets that were found in the gun. And then after testing by the Florida Department of Law Enforcement, it was confirmed that the casings were fired from the same exact weapon that was located by law enforcement, Your Honor.
And again, Judge, we have no ballistics report here, so all we have is what this officer writes in the warrant. There's nothing else to support the allegation that these bullets came from this gun. Mr. Brown told the police he did not know the occupants of the vehicle had no involvement in the shooting. Without more than this warrant to arrest, I would submit to the court that a bond should be set for Mr. Brown.
All right. Thank you both. Per Yasaza v. State, I do find in the affidavit for first appearance purposes that the proof is evident or the presumption is great, and I will hold you, sir, on this charge, the attempted premeditated murder, without a bond at this time. That will not stop you from seeking an Arthur hearing before a division judge, at which time the state will present evidence and witnesses, and your counsel will have the opportunity to cross-examine. Today you'll be held without bond, and you're also to have no contact with the alleged victim. Stay 500 feet away. Don't call, text, write, email, or try to find them on social media. Good luck to you, sir.
Your Honor, at this
Yes.
time, we'll also be invoking Mr. Brown's right to remain silent and advise the state and law enforcement that they are to make no effort to contact him, to speak with him, or communicate with him in any way without prior notification of counsel.
All right, very good. Thank you. Good luck to you, sir. And Joseph Trinjowski.
Judge, I've been advised he's a medical reset.
Oh, okay. All right. There's one other gentleman I see. I know we have Mr. Aguiar. We're waiting on.
There's a perfection, Your Honor.
Oh, there's a perfection. I don't think I got that one.
Yes. It's
Mr. Santiago?
yes, Your Honor. What I was advised is that the court found probable cause for robbery with a weapon. The state asked for 24 hours, since there's mention of a revolver in the probable cause affidavit, to contact the arresting deputy about possibly supplementing the report with an allegation of robbery with a firearm or deadly weapon. I was advised by the assistant state attorney that was present yesterday, upon speaking with Deputy Angel Rivera, they recovered the alleged firearm, and it turned out to be actually it was a lighter that did appear to be a real firearm, but it was not in fact a firearm. So he was charged with robbery with a weapon. So we're asking to proceed at this time.
Oh, and the judge didn't set bond.
No, I believe that it was waiting for see what happened with the perfection.
Got it. All right, let me just take a quick look at this affidavit then. Okay, so based on a review of the affidavit, sir, I'm going to find probable cause for robbery with a weapon. And does he have any priors?
Mackenzie, do you still have notes on him from yesterday? Okay. Yes, Your Honor. The state, even though it is it's still a first-degree felony, though it wasn't a firearm, certainly Mr. Santiago intended to have the victim believe it was a firearm and causing fear in that alleged victim. Based on that and his criminal history, the state's going to be requesting a $50,000 bond and no victim contact. In 2014, Mr. Santiago was convicted of attempted burglary of a dwelling and unlawful use of false name ID. He was sentenced to 40 months in state prison and classified as a habitual offender. 2014, fleeing and eluding law enforcement, he violated probation, sentenced to 40 months state prison. 2013, burglary of an occupied conveyance, violated probation, sentenced to 40 months Florida state prison. 2013, possession of oxycodone with intent to sell or distribute, possession of lorazepam, violation of probation, 40-month state prison. 2012, he was convicted of battery, and 2009, grand theft auto, and he violated his probation.
Thank you. And Mr. Romero?
Judge, Mr. Santiago, he's 26 years old, born and raised in South Florida. He lives in Pompano with his mother. They've been residing at that address as long as he can remember. His mother's been residing at that address. His mother is a caretaker. That's the person that's going to help post his bond. As far as his employment, at this time he has nothing formal. He does landscaping whenever he can. He goes yard to yard trying to cut people's grass. He collects disability. He collects about $500 per month. He does have other members of his family, specifically his grandmother, that lives in Broward that he's very close with. Judge, at this time, considering his lack of financial resources, Judge, he's asking you to consider a low monetary bond. We'd be asking for $1,000, and also, based on the low bond, he would be asking as well. We would ask the court to entertain placing him on pretrial. So therefore, he wouldn't oppose any sort of conditions as far as with the GPS monitor in order to alleviate any of the court's concerns. And that's why he's hoping Your Honor would set a low bond on his case today.
In addition to that, Judge, we don't even know what this lighter looks like or how closely it actually resembles some type of a weapon. No photograph of that has been brought before the court this morning. The state's asking for an extremely high bond. And I understand, Mr. Santiago does have a criminal history, but based on the facts of this case, according to the probable cause affidavit, a show-up, which is inherently suggestive, was conducted, and the victim was not able to make a positive identification of Mr. Santiago. The probable cause affidavit states he confidently identified Santiago. I don't even know what that means, quite frankly, but it's certainly not a that's him. It doesn't appear that way. I'm sure if Mr. Santarelli had said, yeah, that's the guy that did it, that would have found its way into the probable cause affidavit. Confidently identified him sounds like extremely vague language to me, which should be interpreted to the benefit of Mr. Santiago. And we don't know how this show-up was done. We don't know any of the circumstances under this presumably and inherently suggestive identification process. There's no sworn testimony from the victim in the probable cause affidavit. The lighter, which is rather confidently described by the officer as a revolver, it turns out the officer's wrong about that, is somewhere near Mr. Santiago, but not on him. A witness whose name we don't have and don't know says that that he saw Mr. Santiago seated adjacent to it. Well, who is this person? We have no sworn testimony from that individual. We don't even have a name of that individual. So for the state to be asking for such a high bond in this case, based on the allegations here, in which no robbery was ever even accomplished, it's an attempt at best. The victim is able to lock himself in the store and prevent Mr. Santiago, if it was Mr. Santiago, from committing any type of offense. So I'd ask the court to entertain Mr. Romero's recommendation for bond in this case, Judge, based on the weakness of this probable cause affidavit.
All right, thank you. I'm going to set a $25,000 bond, sir, to have no contact with the alleged victim in the case. Stay 500 feet away. Don't call, text, write, email, or try to find him on social media. Good luck to you, sir. Thank you.
Judge, is this an attempted robbery with a lighter? Is that what you're finding?
Your Honor.
An object capable of expelling a flame by some form of combustion?
And Your Honor, we'd have no objection to probable cause for attempted robbery with a weapon. Certainly his intent was to use it as a weapon.
Well, we don't know that. I think it's attempted robbery. I don't think it's with a weapon. It's obviously not with a weapon. It's with a lighter.
Thank you so much, everyone. All right.
Is that an attempt you're finding, though, Judge?
Okay.
Juan Aguilar?
Say I'm gonna rob you.
Mr. Aguilar?
Good morning, Solange. How are you?
Good morning, Your Honor.
All right. We have the Spanish interpreter here. Madam Interpreter, if you raise your right hand, do you swear or affirm that you'll accurately translate from English to Spanish and Spanish to English to the best of your ability?
I do.
All right.
Solange Sands, Your Honor.
Thank you. All right. Very good. Mr. Aguilar,
Señor Aguilar,
can you hear the interpreter?
¿puede escuchar al intérprete?
Sí, 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 la escucho.
All
Yes,
right.
yes, I hear her.
Very good. I'm Judge Davis.
Yo soy el juez Davis.
You're charged with failing to stop or remain in an accident involving serious injury,
A usted se le acusa de no permanecer o quedarse en la escena de un accidente que involucró lesiones serias,
giving false information to law enforcement knowingly,
entregar información falsa con conocimiento a la policía
and operating without a valid driver's license.
y conducir sin licencia válida.
I'm going to find probable cause for these offenses, sir.
Decido que hay motivo fundado para estos delitos, señor.
I'm going to ask the state if you have any prior criminal history.
Le voy a preguntar al Estado si usted tiene antecedentes criminales.
No, no tengo, no.
No, I don't have any.
No, okay, all right. I'm just
Bien.
asking the state attorney. You don't say anything, okay?
Le voy a preguntar a la fiscalía. Usted no tiene que contestar, señor.
Well, other than other than that. He had a DUI in 2005.
Tuvo un DUI en el 2005.
Sí.
Yes.
No, you don't have to say anything. You have the right to remain silent.
No es necesario que usted diga nada,
You
señor.
don't have to say anything.
Tiene el derecho de mantener
Right,
silencio.
right now, the state is giving me some information.
Es solo que el Estado me va a dar información.
Anything else, Mr. Leonard?
Just
Okay.
the part
Just the
DUI.
DUI. Okay.
Vamos a ver si hay algo más. No, solo el DUI aparece.
Okay. Sir, let me ask you, do you have a job? Are you employed?
Señor, quiero preguntarle, ¿usted está trabajando?
Sí, sí.
Yes, yes, I do work.
What is it that you do?
¿En qué trabaja?
Yo corto árboles.
I trim trees.
Okay. How much money do you make on average? Do they pay you by the hour?
¿Cómo cuánto gana usted? ¿Le pagan por hora?
16 la hora.
16 an hour.
Okay. Do you work 40 hours a week?
¿Trabaja 40 horas a la semana?
40 y más en vez.
40, sometimes even more.
Okay, good. All right, I'm going to set a $2,500 bond on count one
Voy a fijar una fianza de 2,500 para el primer cargo
and release you on the other two charges, so it'll be a total of $2,500.
Los otros dos cargos le dejo en libertad bajo palabra, así que el total es 2,500.
And you're not allowed to drive.
Thank you. Le queda prohibido conducir.
You understand that you cannot operate a motor vehicle?
¿Entiende? No puede conducir un automóvil.
No puedo conducir, lo entiendo muy bien.
I cannot drive. I understand very well.
All right. Good luck to you, sir.
Buena suerte, señor.
Take care.
¿Te puedo hacer una pregunta?
All right. All right, any other matters?
No, sir.
All right, thank you, everyone. I'll see you at 1:30.
Erica,
system off again.
Hey, good morning. Did you have a Calvin Lee for magistrate today?
Calvin Lee.
Calvin with a K?
Okay, now do your system mute?
You have a hard card? Yeah. All right, will you bring her?
All right, and now I'll go to juveniles. And now I'm going system off.